Question 111. When a mortgage debt is paid in full, releasing the property from a lien, the mortgagee must provide the mortgager with A. Certificate of discharge, B. Sheriff's deed, C. Documentation of release, D. Payoff bonus. Correct answer is A. Certificate of discharge. Another name for the certificate of discharge is satisfaction of mortgage. The mortgagee must record this discharge certificate within 30 days or incur a $500 penalty. Question 112. A percolation test would likely be used for A. Mineral deposit measurement, B. Building a home septic tank, C. Oil well maintenance, D. Determining an air quality index. Correct answer is B. Building a home septic tank. A percolation test is used to determine the absorption rate of soil. This is crucial for determining the suitability of land for a septic system. The test helps ensure that the soil can properly drain wastewater and prevent contamination. The results of such a test are required to properly design a septic system. Question 113. A potential buyer signs an option contract with an owner, properly backed by consideration. The owner dies a week later. The option is A. Void, B. Must be renegotiated, C. Unenforceable, D. Binding on the owner's heirs. Correct answer is D. Binding on the owner's heirs. An option contract, when properly supported by consideration, is generally binding on the parties involved. The death of the optioner, the owner in this case, does not automatically invalidate the option contract. The option remains enforceable against the owner's estate or heirs, who are now obligated to honor the terms of the contract if the optionee, the buyer, chooses to exercise it within the specified time frame. Question 114. The following is true about open mortgages. A. Has overdue payments and is available for foreclosure by the lender at any time. B. Describes a loan secured by a property that can be paid off without penalty at any time before the loan's maturity date. C. Has a very low threshold of creditworthiness needed to open it, so almost any borrower can qualify for it. D. Both A and B. Correct answer is D. Both A and B. An open mortgage allows the borrower to prepay the principal balance, either partially or entirely, without penalty. This is the defining characteristic of an open mortgage. Question 115. When such terms as adequate, valuable, or sufficient are mentioned in a contract, they usually refer to A. Character of the offerer, B. Availability of funds, C. Attorney fees, D. Consideration. Correct answer is D. Consideration. In contract law, adequate, valuable, and sufficient often describe the consideration exchanged between the parties. Consideration is something of value, a promise, an act, or forbearance that is exchanged between parties to a contract. It's a necessary element for a contract to be legally binding. The terms adequate, valuable, and sufficient suggest that the consideration being exchanged is of enough value to make the contract enforceable. Question 116. Wayne owns a home in suburban Sacramento, with the boundary of his property bordered by the city street. A large palm tree at that end of Wayne's property has rotted and, during a particularly stormy day, falls onto the road, crashing into Norman's car as he drives by and seriously injuring him. If he sues Wayne for damages, Norman will likely A. Win, because Wayne should have removed the rotted tree from his property. B. Win, because Norman was seriously injured. C. Lose, because Wayne did not know the tree was rotted. D. Lose, because the storm causing the tree to fall was an act of God, not Wayne's fault. Correct answer is A. Win, because Wayne should have removed the rotted tree from his property. The general rule regarding duties owed to persons outside the owner's land is that the owner has no duty of care with respect to natural conditions, such as trees or rocks or other naturally existing objects. However, this general rule only applies to rural areas. Here, Wayne's land was in an urban setting, so he owed Norman a duty to keep him safe from naturally existing conditions on his land. Wayne has a legal responsibility to maintain his property in a reasonably safe condition. Even though the tree fell due to a storm, the fact that it was already rotted is key. A property owner can be held liable for damages caused by a hazardous condition on their property if they knew or should have known about the hazard and failed to take reasonable steps to correct it. A rotted tree is a hazard that a reasonable homeowner should be aware of and address. The storm might have been the immediate trigger for the tree falling, but Wayne's negligence in maintaining the tree is the more direct cause of the damage to Norman. The act of God defense is unlikely to succeed if the hazard, the rotted tree, pre-existed the storm. Question 117. The area between the bottom of the floor joists and the ground is called the BTL. A. Joist to ground ratio. B. Crawl space. C. Under the floor dimensions. D. None of the above. Correct answer is B. Crawl space. The space between the bottom of the floor joists, the structural members that support the floor, and the ground is called a crawl space. It's a shallow, unfinished space beneath the lowest floor of a building. Crawl spaces are common in homes with raised foundations and serve several purposes. Access. They provide access to plumbing, electrical wiring, and other utilities located beneath the floor. Ventilation. They can allow for ventilation under the floor, which helps prevent moisture buildup and potential structural problems. Foundation support. They can provide support for the foundation and help distribute the weight of the building. According to the FHA, the minimum amount of crawl space must be 18 inches. Question 118. A property is sold at a foreclosure proceeding for $200,000, but the property owner owes a total of $250,000 to the lender on the mortgage. The difference of $50,000 is called A. Loan workout. B. Deed in lieu of foreclosure. C. Short sale. D. Deficiency judgment. Correct answer is D. Deficiency judgment. Foreclosure. When a borrower fails to make mortgage payments, the lender can foreclose on the property. This means they can seize the property and sell it to recoup the outstanding loan balance. Sale price versus loan balance. In this case, the foreclosure sale only generated $200,000, while the borrower still owed $250,000. This leaves a $50,000 shortfall. Deficiency judgment. A deficiency judgment is a court order that the lender can obtain against the borrower for the remaining balance owed after a foreclosure sale if the sale proceeds are insufficient to cover the debt. It allows the lender to pursue other assets or income of the borrower to satisfy the debt. Question 119. A statement by a real estate agent such as, "There is no better house on the market in this price range than this one," would likely be considered an example of A. Puffing. B. Opinion. C. Misrepresentation. D. Deception. Correct answer is A. Puffing. Puffing is exaggerated or boastful statements about a property's features or benefits that a reasonable person would not take as a literal representation of fact. It's considered harmless exaggeration and is generally not considered misrepresentation. Saying, "There is no better house on the market," is a classic example of puffing. It's subjective opinion, not a verifiable fact. In order to prove false advertising, it must be shown that the statement or representation was deceptive. False advertisement is motivated by a desire to deceive or mislead the public. On the other hand, puffery is usually a matter of opinion rather than a factual representation. Question 120. Which of the following is an implied covenant in a lease? A. Property description. B. Renewal terms. C. Quiet enjoyment. D. Security deposit. Correct answer is C. Quiet enjoyment. Quiet enjoyment is an implied covenant in most leases. It guarantees the tenant's right to possess and use the property without interference from the landlord or anyone claiming through the landlord. It doesn't have to be explicitly written in the lease. It's implied by law in most jurisdictions. The other options are typically express covenants, meaning they must be specifically stated in the lease to be enforced.